Hey entrepreneurs, we're here today to talk about the business to business exemption to the ABC test from AB5 about independent contractor classification. This is going to be one of a few in a series we're doing about all of the exemptions to AB5. This is just about the exemptions. So to recap, if you want to get a deep dive into AB5, which I encourage you to do before you watch this video, please, we've done a very long one just on the ABC test, and to go into real detail about how to figure out if you or your worker is a contractor or an employee. So please go check that out first. We'll have links all over the place. But in the meantime, we're here to just talk about the business to business exemption. So to recap quickly, the ABC test is a pretty new test in the last couple of years from California that made it even harder to become classified as an independent contractor in the state of California instead of an employee. So AB5, which is the law that created and codified the ABC test, and its update AB2257, has a long list of exemptions. And if you fit into an exemption, then the new rule doesn't apply. The old rule called the Borello test applies. So the exemptions are very long and very complex, and that's why we're breaking it up into multiple different videos. So today we're talking about the one that's been commonly referred to as the business to business exemption, that really governs when two businesses are working together. So that's what we're going to do today. So stick around if you want to hear about the B2B exemption. So before I dig in, I'm Gali Aharoni Schmidt. I'm a lawyer in California. I own a law firm based out of Oakland, where we work with small businesses and kind of anything that comes up as outside in-house counsel. So we've been doing a lot of consulting about independent contractor classification since this law came out. So we're just going to dig in then. I'm going to share some slides with you. And we're gonna do this thing. So what I'm gonna do is go through all of the factors that you have to hit in order for the business to business exemption to apply. So first of all, I need you to remember that in this particular test, every single one of these factors has to apply in order to pass this test. And if you pass this test, it doesn't automatically mean that the worker is definitely a contractor. It means that we then apply test number 2, the Borello test, which we talk about in detail in the longer video about classification. And we apply that test instead of the AB5 test to figure out whether this person is a contractor instead of an employee, okay? So we're gonna go through these one by one. So the worker is exempt from using the AB5 test and uses the Borello test instead if, number 1, there is a business entity that is providing services to another business. So what this means is the worker should be a business entity and not just an individual doing work for you. So business entity doesn't have to be an LLC or a corporation. So that's something that a lot of people have been getting wrong about this test, actually. A business entity can be any type of entity that includes a sole proprietorship. So it's okay if the person is just a sole proprietor, but it still needs to pass this sniff test of, is it an actual business or is it just a random person who's doing work for you, okay? So some of the other factors we're gonna go through, we're gonna speak to how to tell whether it's a kind of real business or not. But regardless, it has to be a business, any kind of business, but it has to be a business, and it has to be kind of business on both sides. The next one is that the worker has to be free from control and direction of the hiring company. So that means that the person doing the work, hopefully contractor, the person hiring them, the business hiring them, really is only supposed to have control over the outcome, not of the actual process. So the example I use a lot is, let's say I'm hiring a plumber to come fix the sink in my law firm's office. So I can tell them that I want them to fix the sink. It's got a leak and I need them to come check it out and fix it. I can't tell them when to show up and how to do it and what techniques to use and what tools to use and which of their workers to come. I don't even know enough about plumbing to tell you other factors, but basically I can't tell them how to do it. I can only tell them the outcome that I want. And we want to see that as much as possible. There should be as little control over the work that they're doing as possible. The next one is one of the hardest factors to hit successfully in this test is that the contractor is supposed to be providing services to the business, not the business's customers. So that means in the example I just gave, satisfies this easily. The plumber is coming and doing work for me, the business. They're not doing work for my customers, right? But if I had, say, a paralegal that I'm having help draft documents for me, that paralegal is going to presumably be doing business for my customers. If I'm hiring a paralegal to help me draft a contract for one of my clients, then they're doing work for my customers. So this can be a hard one to hit, but there is a new exception to this exception. So the only circumstance in which it's okay for the contractor to do work for the customers and not just the business itself is if the contractor and their employees are only working under the name of the contractor's business, and the contractor regularly has contracts with other businesses too. So in my paralegal example, if I am hiring an outside paralegal to do the work and I'm just kind of, they draft the contract for me and I send it to the client and I pretend like I did all the work myself, that's a no-go under this rule. But if I tell the client that I'm bringing in a third party and the work is being done under the name of the paralegal's business and the client knows that, and this paralegal business has lots of other lawyers that they work for and do contracts for, that's actually going to be okay under this situation. But be careful of this, because most of the time when I see people working with businesses who are contractors, this is not the model that they're using. Okay, so be careful there. It's a hard one to hit. The next one is that there is now a requirement in order to satisfy this rule that there is a written contract between the two businesses. And on top of that, in the contract, there has to be terms about the payment amount, including the rate of pay, and there has to be information about the due date of payment. So this isn't, I bolded this one as well, because I think this is going to be another one that accidentally messes people up. You can hit every single one of these other factors and not have a written contract, and you can't use this exemption. Okay, so required to have a written contract, and it's a good idea anyway, and you have to have that information there about payment. The next one is similar. It's that the worker business has to have a business license. So I see this one mess people up a lot too, because a lot of businesses don't even know they're supposed to have a business license. So you need to make sure that the contracting business has a business license in the city that they do business. So one question I get a lot here, which is a really good question, is, so let's say I'm the one hiring the contracting business. What is my responsibility to figure out whether they have a local business license? That's, how am I supposed to know that? And it's kind of weird for me to ask. So there's a couple of different ways we can do this. First of all, I can just ask. I can require that they show me proof, that they show me their business license in order for me to do business with them. That's a perfectly valid thing to do, especially if you're trying to use this exemption. But I know that makes a lot of people uncomfortable and they don't necessarily want to ask. And it's then putting the burden on me, right? When it shouldn't necessarily feel like my burden. So another option that we do for people sometimes is in that written contract, which you're required to have, we can have a provision in there that says, you, the worker, the contracting business, are affirming to me in this contract, so legally binding, that you have a business license and that you're assuring me that you do. So that kind of puts the burden on the contractor business to assure me that they have one. And it means if they're lying to me and they don't, then they're in breach of contract. So you can also do both, which is, really cover your bases, but at least do one or the other, just to make sure you're doing your due diligence and to make sure you're not accidentally breaking this exemption. The next one is the contracting business is supposed to have a separate location where they do work. So this, first of all, can be the contractor's home. If their business is working out of their home, that's totally fine. It's totally fine that it's, it can be wherever they want it to be. The main thing is that to satisfy this rule, they want to make sure that there's just somewhere else that the contractor can work out of if they choose to. So it just means that there just has to be some place other than the place they're doing the work for you that they can do work if it's reasonable and if they choose to. So they can come on site if it makes sense for them to do so, but there just has to exist a separate location. The next one is that the contractor should be customarily engaged in an independent business of the same nature of the work performed. That just means, whatever they're doing for you, they should be doing that professionally for other people too. They're a professional fill in the blank. They're a professional plumber, they're a professional paralegal, they're a professional, whatever it is they're doing for you. It's what they do. It's kind of related to the next one, which is that they can contract with other businesses for similar services. So that means that the contractor needs to have the ability to work with other businesses at the same time. So they're not required to actually have other open clients at the same time. It's okay if they're just working for you right now, but they have to have the ability to do so. And that means that your contract with them can't have any restrictions at all in there that say you can't work for other people, including your competitors. You can't have any non-compete provisions in there that say, while you're working for me, you can't work for this person in particular or work for other people in general. So again, that's a big change for a lot of these similar types of relationships, where before a lot of people tried to throw in non-competes in there that said, while you're working for me, you can't work for my competitors. So make sure you're not accidentally breaking that one either. All right, these are the last few here. The next one is the contractor business has to advertise their availability to provide similar services. So again, it doesn't necessarily mean they have to have TV ads and billboards and things, but do they have something like a website? Do they have ads somewhere? Do they have business cards? Are they on, do they have a, Google My Business page? Do they have something that signals to the world that they're a business and that they are available to be hired to do the same sort of work that they're doing for you? The next one is the contractor is supposed to provide their own tools. So the rule says they only have to provide their own tools consistent with the nature of the work. So that means this is relative to what they're doing for you. So of course, in my plumber example, I'm not going to be providing them with tools. That would be crazy and weird. They're going to bring in all of their own tools that they need. But if I had, let's say, a cybersecurity expert come into the office and work on making sure all of the office computers were secure, I'm probably going to need them to use our computers and to use our software. And I'm going to have to give them access to maybe some proprietary stuff that they need access to in order to do the work. And that makes sense, right? And so really, they're supposed to use their tools to the extent necessary and reasonable under the circumstances. So if there's some reason that they have to use your tools, then that's still fine, but it's going to be in the context of the relationship. Next, the contractor has to be able to negotiate their own rates. So, this kind of makes sense. If a business is a real business, they're going to have the ability to decide how much it costs to do the work. So that one seems pretty straightforward, but it does come up a lot, especially when people are working with lots of contractors at once. Sometimes they kind of just say there's a flat rate for something, but the contractor has to be able to decide, at least have the ability to negotiate the rates if they choose to. The next one is they need to be able to set their own hours and the location of work. So again, this is really context dependent, like the tools. So of course, with my plumber example, they're going to be able to decide when they come to fix my sink, but they can't tell me they're coming at 2 o'clock in the morning. It's, they have control within reason. And same thing with the location of work. Just like the tools, if there's no reason for them to be on site, then they get to choose the location. So if someone's building a website for me, I can't really require them to come into my office. That doesn't make sense. But again, if they're coming to fix the plumbing, of course they have to come on site. And so again, another example of this is, let's say someone is doing catering for a movie set. Of course, they have to show up at certain hours and certain location, because that's the required for the job, right? So a lot of this comes down to context, but to the extent reasonable based on the relationship and the work, they set their hours as much as possible. They set the location as much as possible. So also to note that this exemption does not apply to businesses with contractor licenses, but it applies to pretty much everyone else if there's a business on each side. So again, to recap, every single one of these factors is required to be hit if you want to use this business to business exemption. That means that classification between contractor and employee can come down to whether someone has a business license or whether you have a written contract. So be really, really careful here, and make sure you're hitting all of them and getting all the nuance of all of them. So that's the time I'm going to spend on B2B right now. I again want to encourage you, and I'm going to say this over and over again, if you feel like this exemption might apply, I encourage you not to assume that it does, because I hope you got from this that every single one of these has nuance and is really context-based. So I encourage you to talk to a lawyer or another expert about this before you try to apply this test, because I just don't want you to apply the wrong test accidentally and get it wrong and get sued or audited. I don't want you to get in trouble by accident. Okay, so thank you for joining me today. Again, this is going to be a series. We're going to go over all of the exemptions in more detail. And if you found this helpful, please send it to other people who might also find it helpful, and stick around to check out our upcoming videos too. We post a lot of these, but also, again, we're going to have a whole series on these. So if you want to stay tuned for our other videos and articles about this, you can follow us on our social media. You can follow us on our YouTube channel. All of those are available on our website, aharonibusinesslaw.com, and we'll link all that stuff everywhere. So hope to see you again at a future one. Thanks so much.